So we have seen many videos about concurrent delays. And this video will be seeing about how tribunals see the concurrent delay. See, concurrent delays are discussed in site meetings. They are discussed within the monthly progress meeting between the employer and the contractor. Then they move towards disputes. Then they go to the tribunals. At the table of the tribunal, the view is completely different what you see from the site. So let's see how these are seen by the tribunals and what are the laws used to view a concurrent delay. So what is a concurrent delay? The tribunals generally begin by asking, was there a true concurrency? True concurrency shall have these characteristics. Most of us stop with the first one. Two delay events occur at the same time. That is not the only characteristics of a concurrent delay. Each event independently affects the critical path. One event is employee's risks, the other is the contractor risk. See, the second point, each event independently affects the critical path means at a particular time overlap, there will be a particular activity, and that activity shall be affected by both contractor and subcontractor. So we have WhatsApp groups, and most of the queries will be on this. I will get DMs saying that we have an concurrency and the contractor is not accepting, or the employer will come that the contractor says that we have concurrency, the employer is not accepting. If you are not able to prove all these three things, even the tribunals will not accept it. So now the same particular activity shall have a dependency on the employer risk completely different and a contractor risk that is completely different. It should not be consequential. For example, if the contractor is depend on this employer's pre-request, that doesn't mean that the delay is concurrent. For example, there is a delay in drawings to start a particular job, and there is a delay in fabrication by the contractor to start a particular job. That is not a concurrent delay. If there is a delay in the drawings by the employer side to start it, and also there is a delay in mobilization from the contractor side to start the particular activity, then that is a concurrent delay. So importantly, tribunals reject loose or commercial use of the word concurrent. They require critical path concurrency, not merely overlapping events. Many tribunals refer to guidance from the Society of Construction Delay and Disruption Protocol, which distinguishes between what is a true concurrency, sequential delays, dominant cause situations. The next is the burden of proof. Usually, tribunals hold that, as per mostly common law and civil law, the burden of proof is always lies with the party that seeks the relief. So usually for a contractor seeking an EOT, extension of time, they must demonstrate the employee delay. They must show it impacted the critical path. They must show the delay overlapped with the contractor delay. Without robust delay analysis, concurrency arguments usually fail. This is why tribunals give significant weight to time impact analysis, as planned versus as built analysis, contemporary programs, updated critical path submissions. But most of the contractors who go to arbitrations doesn't have strong contemporary programs and updated critical paths. Extension of times. The prevailing approach by the tribunals. Most tribunals adopt what is often called the Malmaison approach derived from an English case. Henry Boot Construction Limited versus Malmaison Hotel, Manchester Limited. The principle is, if there is a true concurrency, that it obeys all the prerequisites we have discussed in the previous slides, the contractor is entitled to extension of time, even if there were also delay from their side. Why? The employer cannot benefit from its own delay. The employer has made a delay and they cannot benefit by their own delay by implementing the liquidated damages. So they waive from their rights to levy the liquidated damages because there is a delay from their end. This approach is widely followed in international arbitrations, even outside England. Prolongation cost, a different story. So here the tribunals become stricter than they are liberal for the time. While UOT may be granted, but most tribunals deny prolongation cost during period of true concurrency. Reason is why the contractor would have been delayed anyways due to its own default. Okay, and there is therefore no additional cost follows purely from the employee delay. Thus, the common tribunal position is like below. I have made a table on that. Relief outcome in the true concurrency. Extension of time? Yes, usually granted. Liquidated damages? No, usually not imposed. Prolongation cost? Usually rejected. Apportionment. This is increasingly used in civil law jurisdictions. Instead of all or nothing. So they allocate responsibilities by percentage. They divide time and cost impact for the concurrent period. So in international arbitrations where the contract does not expressly address the concurrency, and of course most of the contracts do not express what is true concurrency. Apportionment is especially used when concurrency is not perfectly simultaneous, delay analysis is imperfect. Sometimes it may be imperfect due to the non-availability of the inputs, and both the parties materially contributed to the delays. The dominant cause argument. Contractors often argue the employer's delay was the dominant cause, and the employer goes vice versa. Tribunals accept dominant cause reasons only when the events are not truly concurrent. One delay clearly overwhelms the other. So in case of genuine simultaneous critical delays, tribunals reject dominant case theory when both the delays are very important and dominant. The effect of the contract wording. The tribunal's approach ultimately depends on the governing law, express concurrency clauses in the contract, risk allocation provisions in the contract, or like Abrahamson risk principle when it comes to FDIC. Some modern contracts attempt to exclude UOT in concurrency. Tribunals examine such clauses carefully, especially where they distribute balanced risk allocation. Under many FDIC-based contracts, if the employer risk even causes delay, UOT is generally available. However, cost entitlement is limited if the contractor has not made delay or made it. Civil law versus common law perspectives on this. Common law trend is mostly dependent on the 𝐁𝐸 principle we have seen. UOT is allowed, cost is rejected, and no liquidated damages is allowed during the concurrency. Coming to the civil law trend, there's a greater flexibility and mostly depends on this apportionment of the time and cost. It focuses on the causation and the weightage, equity of the causation. International tribunals often adopt a blend, a pragmatic approach rather than rigid national doctrine. So practical observations from arbitration practices. From real arbitration experience, tribunals typically they dislike the theoretical concurrency arguments unsupported by program evidence, focus on the critical path impact, require clarity on timing overlap, prefer contemporaneous records over retrospective reconstruction, they scrutinize the expert delay analysis very rigorously. Weak delay methodology often leads to complete rejection of concurrency claims, especially prospectively used delay methodologies like IAP. Strategic lessons for contractors and employees. So, first for the contractors, to prove the critical path impact, not just an event overlap. Separate the time entitlement from the cost entitlement. Avoid overclaiming prolongation during concurrency. Maintain updated programs. For employer, establish contractor's culpable delay clearly. Challenge the concurrency technically, not theoretically. Examine whether delays are truly simultaneous. So, coming to the conclusion, what's the takeaway? Tribunals do not treat concurrent delay emotionally or politically. They treat it very analytically. And the modern arbitral position can be summarized as true concurrency must be strictly proven, extension of time is commonly granted, prolongation cost is often denied, apportionment may apply depending on the jurisdiction and contract, evidence and methodology determine outcome more than legal theory. Ultimately, concurrency disputes are rarely won by legal arguments alone. They are won or lost on the quality of the delay analysis. If you have any other topics should have been discussed, this was specifically asked by one of the followers and subscribers. So that's why we took this topic. And if you have any consulting requirements for delay analysis, please contact the number on the display. And if you are looking for any trainings for the departments, contract departments or the planning departments on contracts management, claims management, delay methodologies, please do contact us. Thanks for watching again. Take care. Bye.